G'day, I'm Andrew Lovett and this is another Tax Insight. Today's topic is new tax whistleblower rules that have been introduced to Parliament as new legislation. So late in 2017, the government introduced new legislation to beef up the whistleblower rules in three different areas: companies, banking, and also for tax. That bill at the moment is still before Parliament, but I expect it will pass largely as it is. And we're going to focus here on the tax whistleblower rules. So the purpose of the rules is to provide protection to someone who acts as a whistleblower where they believe a taxpayer is avoiding tax or undertaking some sort of really dodgy tax scheme, and they report that to the tax office. There's been some whistleblower rules in the Tax Act, but they were fairly weak. And these new tax whistleblower rules beef up the protections for the whistleblower, and it's harmonised with the protections that are being put in place for whistleblowers in respect of companies or banks. So the sorts of people that might be a whistleblower might be an officer of a particular company, it could be an employee, it could be a spouse or a child, it could be a supplier or the employee of a supplier. All of those are deemed to be whistleblowers that are subject to the protections of these new rules. Now, for the rules to apply, the whistleblower must give the information to an eligible recipient. That's a complicated word, but you can't go to the media, for example. The whistleblower could give it to the company's auditor, could give the information to a tax or a BAS agent, could give the information to one of the officers of a company, a partner of a partnership, or the trustee of the relevant trust. The whistleblower could give the information to someone who's been specified as being the right person to receive whistleblowers' concerns by the company, by the business. In the explanatory memorandum for the new legislation, there's an example given which illustrates things. Andrew believes his current employer, a multinational business, is avoiding tax through the use of artificial arrangements and offshore entities, and has disclosed this to the tax office. Andrew regularly contacts the tax office seeking updates on action taken in response to his disclosure. However, the tax office can't actually talk to Andrew about it because of their responsibility to keep taxpayers' information private. Andrew decides to provide the relevant information to a newspaper, which subsequently publishes it. As a consequence, Andrew loses his job and is unable to get another job in the field because his former employer won't provide him with a reference. Andrew's disclosure to the media is not eligible for protection under the tax whistleblower protection laws, and he is unable to seek compensation under those laws. Andrew's disclosure to the media is not an eligible disclosure under these new rules, and he's not able to claim compensation for the loss of his job. So an important part of this new legislation is it provides an immunity to the whistleblower against a civil case or criminal or pecuniary penalties that might be levied against them. There's another example in the explanatory memorandum which explains this pretty well. Brian is studying accounting and works casually as a chef at a restaurant where he gets paid cash in the hand. The restaurant asked Brian to help with the business accounts. Looking at the accounts, Brian learns that the restaurant is avoiding personal income tax and company tax and is in breach of its superannuation guarantee scheme obligations. Brian decides to disclose the information to the tax office, including the income that he earned as a chef, and which he didn't include in his own tax return. As Brian's disclosure qualifies for protection, the information that he disclosed is not admissible in criminal proceedings or proceedings for the imposition of a penalty. However, as he disclosed his untaxed income voluntarily to the tax office, they may treat the disclosure as a voluntary disclosure in the meaning of the tax rules in determining his liability for penalties in respect of the unpaid tax. So one of the protections in the new whistleblower rules is that contracts can't be terminated because of the disclosure of the information. So that would apply to an employee, but it might also apply to a supplier. In addition to that, whistleblowers can't be victimised under the new rules and are able to seek compensation if that actually occurs. So if a whistleblower lost their job and they have protection under these new laws, they could sue for the loss or damages that arose from losing their job. The whistleblowers also have protection from having their identity disclosed if there was a court action. So whistleblowers have strong protections, are able to claim compensation and have considerable rights arising from these new laws. Perhaps these new rules are a good reminder of your right to keep your tax and accounting information quite confidential. That's been another Tax Insight from LOVETTS. If you'd like to read the full article, go to our website, lovetts.com.au.